All right, we are live.
Yeah,
Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Thank you. Good morning. Welcome to the Massachusetts Appeals Court. This is the June 2nd sitting of our Appeals Court. By use of modern technology, we're Zooming our oral arguments. We're down to 4 cases this morning. The first case on the list is 2019 P1138, Department of Children and Families versus Mother. All counsel are present. I remind you that there are some impounded names and information here, so please be careful. I'd ask you to conduct yourselves as if you were in the courtroom. So when you're not speaking, be aware that you are still on camera, and any movement would be picked up by the other parties. My name is James Lemire. This morning we have Justice Sabita Singh and Justice John Englander as the other judges on the panel. With that said, it's my understanding that the department and the children's attorney are splitting 10 to 5, their 15 minutes. And Mr. Rosenthal, you may begin.
thank you, Your Honor. Good morning, Your Honors. Opposing counsel, may it please the court. I'm Stephen Rosenthal. I represent the appellant mother. The appellant is seeking a reversal of the trial court's orders in this matter. And without waiving any of the arguments previously briefed, I want to emphasize a particular instance in which the trial judge made clearly erroneous findings that improperly led to the termination of mother's parental rights to the older of the 2 children in this case. At transcript volume 1 at page 107, early in the trial, when mother's trial counsel raised objections to various exhibits, the trial judge announced that he would admit all 51 A's and B's for primary facts only and would admit all other DCF reports subject to Mass Guide to Evidence Rule 1115. It was not necessary to object to each and every document in these categories. The trial ended on October 9, 2018, when the trial judge issued findings of fact and conclusions of law nearly 6 months later. His finding 201 stated that the older child, quote, stated to the social worker that he did not want his legs broken. This alleged comment supported his finding 127, which stated in part that the child had, quote, a state of mind of knowledge of at least one instance when his younger half-brother had been hurt while with father. The problem with finding 201 is that the judge violated his own ruling. The only evidence in the record that matches this finding is in Exhibit 84, found in the supplemental appendix at page 11. There, in a report dated January 16, 2018, almost 2 years after the child had been removed from mother's care, the social worker stated that a month earlier, quote, foster mother reported that the child's teacher reported that he had been emotional at school and, quote, had made a comment that he didn't want to have his legs broken. The trial judge's finding 201 matches this part of Exhibit 84 almost word for word, except that instead of being a statement made by the child directly to the social worker, this was a statement allegedly made by the child to an unidentified teacher who relayed that statement to the foster mother, who in turn relayed it to the social worker. The judge not only ignored this multiple hearsay, but failed to follow Rule 1115B2B, which states that hearsay statements in case review reports are admissible for statements of primary fact if the hearsay source is specifically identified and is available for cross-examination. This is the same standard that was adopted by the Luke case this past February by the SJC.
So, counsel, I can interrupt for a moment.
Yes, sir.
Let's assume that you're right. With respect to child C, there was a mistake made in the judge's consideration of hearsay. You still have, it seems to me, a record of the mother knowing findings that seem to be supported by the record that she knew of abuse of her older two children by an earlier live-in, and then she is present, or she's in the same home with someone who brutally abuses another child. Aren't those findings sufficient?
I would say no, Your Honor, because the judge's findings actually said that there was no evidence that mother was complicit in the abuse of this youngest child, the baby, and was not present when it occurred. The police officer who testified and who took a statement from the father of the infant child who was abused, he elicited from the father that all of these incidents in which he injured that baby occurred when the mother was not available or not present.
But there are explicit findings that the mother should have been aware that the child's leg was so severely broken that when the doctor finally saw it 4 or 5 days later, the doctor immediately knew that there was a problem. There were ribs broken. There was testimony from the doctor as to whether or not that would have been noticeable to someone who's 24/7 with the child. What are we to do with those findings?
Well, there's a lot to unpack there, Your Honor. First of all, let's talk about the ribs for a second, okay? According to the testimony of Dr. Barron, those rib injuries had occurred as early February of 2016. Mother observed that the child was having respiratory problems on February 6th. She took the child to the emergency room. The child had x-rays of his torso on February 8th. The child was seen by his pediatrician on February 10th. That doctor found that the child was experiencing no pain. There was no pain elicited by lifting or manipulating the child in any way. The child was then seen about a week later for vaccinations. No pain was observed at that time. The child was seen by early intervention specialists about a week after that. The child was cooing, laughing, lying on his stomach, exhibiting none of the symptoms that Dr. Barron later said would be indicative of injuries to the ribs. Now, with respect to the leg injury, that had occurred sometime around February 25th. And the judge made specific findings that that the child's symptoms, or that the leg became significantly worse after February 27 of 2016. And mother called her pediatrician the first thing in the morning on February 29, about a day and a half later. Once again, there was no indication, nothing in the record to indicate that the mother knew that this was what had happened to the child. And I would say that the pediatrician's testimony was somewhat suspect because supposedly she knew immediately that this was a problem, but instead of calling the police or calling for an ambulance to have this child taken directly to an emergency room that was 15 minutes away from her office, she told the parents, well, take her to the emergency room yourselves. And in fact, although the doctor testified that this was a very quick incident, if you look at the office treatment records, they show that the visit lasted close to 2 hours. He was seen shortly after noontime. Some Tylenol was administered sometime after 1:30, and then the child, with the parents transporting him, arrived at the hospital at about 2:30.
That's an argument. First of all, that's just piecing. There's no finding to that effect. You're piecing together evidence in the record and assuming that the parents didn't delay in taking the child to the hospital. But Secondly, where does that get you? I mean, there's no finding by the judge that Dr. Cummings' statements were suspect. And you're still come up against, I don't think anybody disputes, the child had broken ribs on both sides of their body and 2 broken legs.
Your Honor, with respect to, I don't want to mix apples and oranges here. With respect to the baby, the child, there's no question that the child was abused. Dr. Barron, who is an expert in child abuse evaluations, said that these injuries were the result of physical abuse. However, with respect to the mother's conduct, all that Dr. Barron said and all that the judge found at finding 89 was that Dr. Barron thought it would have been appropriate for the mother to contact the pediatrician sooner. That doesn't sound to me like abuse or neglect. It sounds like poor judgment perhaps. But yes, Your Honor.
Was there information in the record that the mother had knowledge of the father's prior conduct with other children?
She was informed, and she vouched for the father. DCF vetted the father very thoroughly. They knew from June of 2014 that the father was in a relationship with mother.
Well, you characterize it as the DCF vetting this father. Is that within the judge's findings?
Well,
or was there testimony to the effect that he was vetted?
Well, the judge found that, I believe, I may be just referring to pieces of the evidence again, but certainly there was a query in the record, and the judge did make a specific finding that at one point when they were getting ready to reunite the older child with the mother, there was a discussion between the mother and the social worker, and the mother asked, "Is my relationship with this man going to be a problem in reunifying me with my child?" And after checking apparently with other people at DCF, the social worker said, "No, that's not going to be a problem. We won't have a problem with that." And the judge did make that specific finding. If I may, Your Honor, if I hope I've answered your question, I'd like to go back to what I was talking about originally, which is that finding 201 was clearly erroneous because it was based on evidence of a DCF report of an alleged state of mind of this older child. And this was the problem here is that there is no evidence in the record that this older child was present, witnessed, or was a victim of any physical abuse. The only evidence was this Exhibit 84, which came out a year and almost 2 years after the child was removed from the home. In fact, the judge's finding at 127 also had a mistake in it. The judge found that a 51B dated March 7, 2016, a week after both children were removed, quote, reflects that while the child was being transported after emergency custody was taken by DCF, so this is a week after February 29, 2016, he made statements indicating a state of mind of knowledge of at least one instance.
Is your argument that she should be allowed to have child C and not child F? Or put another way, is your argument that child C, that she has a different case with respect to child C?
My first priority is to argue that mother is entitled to custody of both children because DCF did not prove by clear and convincing evidence that she was neglectful with respect to both children. If this court decides that with respect to the younger of the two children, she was found unfit properly, then my argument in the alternative is that the older of these two children had there was no indication that the child was the subject of any physical or emotional abuse.
He only had that child with her in her custody for the first year of his life, and then from December of 2015 to February of 2016, right?
Actually, I believe it was earlier than that. I think it was May 2015 to February 2016. Now, I guess if I understand you correctly, Your Honor, and I'm running out of time, but I think your question is, well, during all that time, didn't the child see something? Well, that was DCF's burden to establish that, and my position is that they did not do that.
I understand that point, counsel. I was headed in a slightly different direction, which is that the unfitness is based on her repeatedly bringing into her life men who abuse her children. Can't that extend to child C, even though, because he'd only been with her for 18 months, it hadn't yet happened to him?
Well, the argument that mother kept bringing this child into contact with abusive men kind of falls by the wayside when you consider that all of her children, in one way, or with the exception of child C, were exposed. In fact, in 2 cases, custody was returned to 2 of those allegedly abusive men. And with respect to child C's biological father, when child C was in a foster care arrangement with paternal grandmother's foster placement was pulled because foster grandmother was exposing this child to his abusive father. And there is evidence in the record, although there was no specific finding on this, but there is evidence in the record that even after the child was placed with the paternal aunt allowed this biological father to take child C to that same pediatrician's office. It's in the record, and I've cited it in my brief.
Thank you, counsel. Your time has elapsed.
Thank you, Your Honors.
Right. The order of the president, is it who's going first? Mr. Peterson, or we have to unmute you. There we go.
All right.
Mr. Peterson, go right ahead.
Thank you, Your Honors. Good morning, Your Honors. My name is Jim Peterson, and I represent the Department of Children and Families in this case. This case is about mother's inability to protect her children from the abuse at the hands of her significant others. For 10 years, mother consistently failed to keep her children safe from her abusing boyfriends and husbands. She failed to intervene when she knew what was happening. She minimized and denied the ongoing abuse. And she did not work to remediate her deficiencies by participating in the services that DCF were offering to her. To quote from one of the cases, it's a 128 case that I included in my brief. I know it's only persuasive, but the facts are very similar in that it's adoption of Yehuda. And in that case, to quote from that, mother's responsibility was not so narrow as to simply refrain from physically abusing the children herself. She also had a responsibility to protect them. And that's what DCF's case was. And even if you read the closing argument of DCF at the trial level, that was what the focus was, that this is an ongoing pattern of abuse on this that goes back to 2003 with Father L and Child L, Father A and Father and Child A. Father L got his child back. Father A was at that time living with mother, and there was a spank on Child L. There was a bruise, rather, on Child L's rear end that appeared to be a spank with 3 finger marks. Even you could still see those. He brought him to the hospital, both to the hospital and to Father L. Apparently, Child L said that this was Father A who had done it. He did not so report to the investigator, unfortunately, but that started with that. Then in 2000.
Then what do you say to, so if you want to go back to Father L and Father A, it seems to me that you muddy the waters. Both of them got their children back.
Yes, Your Honor. Well, actually, this is the issue here, and as it starts to come in.
And how do we accept an argument that says she's so terrible that she should be found unfit and her rights should be terminated when you're relying on evidence related to two fathers who got the child back.
Well, in this case,
The argument's a heck of a lot better when we get to Father C and Father F. Let's put it that way.
and I'll move past on this, in fact, but the reason that some of this is important, as the judge found in some of his findings, finding 10, finding 12, this is the historical ones, mother makes a statement at one point and then dives it back. And she's consistently minimizes any accusation as well. And again, with Father C, which is a big one in 2011, there are 2 incidences. And again, this is with child C and the 2 older children. But it's in that one, again, mother denies that there was ever any abuse. And this is the abuse that actually resulted in Father C going to jail. And even on the stand, she said, she admitted on the stand that the children told her that they were afraid of Father C. And she didn't do anything. In fact, she denied that this abuse was occurring, even though it was clear that she was aware of that abuse at that time. As to child C, Your Honor, as my brother was stating, there's mentioning that the issue as to whether or not the judge credited something that the child had stated, whether or not the child C saw anything or not is actually not relevant to the judge's final conclusion in this case.
You can see that what counsel has identified as clear error.
No, I don't actually. At that point, there was never an objection to any of that at the time. In fact, I would argue it's waived. At that point, it does go to
the judge's finding says he made that statement to a social worker. There's no evidence in the record the statement was made to a social worker.
Oh, I see that aspect of it. If that's true, then yes, then that would be an error. But it's not.
True. I would hope you guys know the record better than we. But that was what counsel identified. I read the finding 201. It says the statement is made to a social worker, and counsel has walked us through and said the only place in the record where that statement can be found, it was multiple level hearsay in a 51A report.
And that is, if that's the case, then that's clear error, but it doesn't affect his conclusions of law. And that's the important part in here, especially when you get to conclusion of law 50. I think this is where the judge actually mentions the factors under chapter 210, section 3C, and all these factors that are applicable as to the parents. One of these is that he cites with respect to child C is factors 2, factors 9. Specifically, they are about the violence that has been there, but they don't require the child to have witnessed any of the violence. In the subletter small 2, the children or another member of the immediate family of the child has been abused or neglected as a result of the acts or omissions of one or both parents. The parents were offered to receive services. It goes on, but there's nothing in there that they
finding are you looking at now?
Well, the quote that I'm reading right now is from chapter 210, section 3, C, subparagraph little 2. What I'm looking at, the judge doesn't spell this out other than in conclusion of law 50, which is on page 45 of his findings and conclusion. The judge just notes which factors are applicable to mother in this case. So his conclusions with respect to child C don't rely on whether or not child C actually saw any of the abuse. They do rely on whether or not there was abuse in the family by one of the, and whether these parents were offered the services to correct them and failed to do it. But this is not something that if child C doesn't witness it, that somehow that means that mother gets the child back. And the judge's conclusions don't rely on any of those findings that state that child C may have actually seen anything. Now, as I argued in my brief, I think that there's no specific conclusion or fact on this, but it is clear that child C was a year old at that first removal in 2011. And this is when there was a litany of things that had happened to child's L and child's A that clearly happened in the home while both parents were there. And it's reasonable, but it's not a finding, but it's reasonable to assume that the child who's there had to have seen something of this. Just like when they tried to reunite child C with mother in the end of January of 2013, she has strict instructions to not leave. That things were going well. It's the first planned overnight, but don't leave without calling the social worker. And that was explicit. She left. She went to somebody else, to Father A's home, gave two different separate reasons, but immediately, almost, when she gets there, there's some sort of incident. I believe mother said it's an argument. It didn't go physical, but it was clearly bad enough that mother left on with the child, did not bundle the child up, 30-degree weather, no way to get home. She's in a different city. It was significantly bad enough to have caused that she left with the child without any of that. And by definition, she had child C with her, who's about 3 years old at that time. Whatever occurred, he certainly would have been a witness to that. So one way or the other, there certainly was evidence in the record that child C was present for some of these things. But again, and I just want to emphasize that the ultimate
an argument with a former spouse that results in someone leaving the home is sufficient to take away a child?
No, this is it. It's any one incident here is really not the issue. The issue is this ongoing pattern, and that when the department attempts to offer her services to recognize domestic abuse, which, by the way, mother never acknowledged that the domestic abuse was an issue in any of her relationships, despite what has happened to all of her children. The department attempted to get her these services to try to get her to recognize it. They tried to do the trauma-informed cognitive behavioral therapy. Mother only took domestic violence class finally toward once this current case started to happen. And then when the person from that class thought she would benefit from the next one because it had a parenting component and a domestic violence component, thought this would be useful to help identify red flags in partners, she didn't want to take it. She ultimately signed up for it. And then she just told the social worker that the only reason she had done that is just to look good for the department.
Thank you.
Thank you.
Peterson.
Thank you for your amount of time. Thank you.
All right. And we have 5 minutes with Miss, is it Lowry? All right, we have to unmute you and we'll get going. Megan? Are we going, do you
unmute yourself?
Oh, you have to unmute yourself. I'm sorry. Go right ahead.
Okay, thank you. May it please the court, Julie Lowry on behalf of the children. Your Honors, both children request that this court affirm the lower court's judgment. I like to make it abundantly clear that at the time of trial, both children supported termination of parental rights then, and they support termination of parental rights today. When looking at this case, I don't want to repeat all of the abuse that the youngest child, baby F, suffered. We've already gone over that, but it's very clear from the evidence. And I would state again that the expert did testify that mother should have known that something was wrong. And I'd like to point out that mother did note that the child's leg did not look right on the Thursday before she reported it to the doctors that following Monday. We've gone through that evidence already. I don't want to keep harping on it, but 13 fractures, some of which that were in the midst of different stages of healing, was clear evidence that that baby had been abused at the hands of Father F. With regards to the perspective of child C, which seems to be the biggest issue here, from his perspective, although there may not have been abuse at the hands of the mini men literally onto him, there is evidence that mother minimized, and she minimized all the abuse throughout the years and failed to protect her other 3 children, and thereby by failing to protect her other 3 children at the hands of the various men that she was involved in, I think the judge properly weighed that evidence in determining the likelihood that something could happen to child C in the
What
future.
do you say with respect to child F about the point that a whole lot of other people saw that child in that 2-week period in February, and none of them, and including professionals, multiple professionals whose job it is to recognize that there's an issue with the child, none of them saw anything? What do you say to that? Isn't that odd?
Well, I don't think it's odd unless they were undressing the child and handling him the way that a parent would.
Okay, I mean, there was one of the, what they call EI, early intervention. Isn't that part of their job, to handle the child?
Not necessarily, and I believe the testimony of the EI person who had come into the home had spent more time talking to the mother about the child and doing an assessment. I don't believe that there was evidence that there was actual physical manipulation of the child's legs. I recall that she had stated they were looking to see whether or not the child would move his head when he would hear a noise in order to assess his hearing and his eyesight with regards to moving his eyes to follow sounds. But I don't recall seeing anything about manipulating the legs. I know he was on the floor. I think they put him on his belly to also see whether or not he lift his head, and I believe that the assessment was
the finding is that the mother should have known that something was up, and the x-rays are horrific, right?
Yes.
But you have her taking, I mean, multiple, I think she had something like 4 or 5 appointments with professionals during a 2-week period. Just on its face, doesn't sound like someone neglecting a child. It sounds like someone who has their child regularly going to see people, none of whom identify this issue. And the judge doesn't really address that. That's one of the points that the mother's lawyer makes, that you have to address the hard questions. That's why I'm trying to ask it.
I understand. Well, I think if you look at the expert testimony regarding that, she made it clear that she wouldn't have expected mom to know that the baby's leg was actually fractured, but that something was awry and something was wrong. And I think when you couple the fact that the mother actually reported to the doctors that the child actually had, quote, bruising from crying, along with the swelling of the leg, and you add in the fact that Father F was somebody who mother had been warned had allegedly injured another baby at a different point in time, I think that it is reasonable for mother to have had some type of a light bulb go off, quite frankly, and say something's just not right here. She also had reported that he cried a lot as well. And so it's not necessarily an expectation that mother knew that the child had this extensive amount of abuse. But I think when you look at the case as a whole with the entire history and all the men that were in her life, and in this particular situation with Father F, mother should have known something was wrong.
Thank you, counsel.
Thank you.
That will conclude the hearing on this matter. The case is under advisement. Thank you, counsel.
We are live.
All right. Good morning again. This is the second matter on today's list. It's 2019-0754 Commonwealth versus Sean Sproul. And Miss, is it Core or Corey?
Core, Your Honor.
Go right ahead.
Good morning. May it please the court. My name is Lisa Core and I represent Sean Sproul. Chapter 90, Section 24 criminalizes the operation while under the influence of certain controlled substances, certain drugs that are defined by Chapter 94C, Section 1. Those are marijuana, stimulants, narcotics, and depressants. Where here, the evidence was that Mr. Sproul possessed 2 controlled substances, fentanyl and amphetamine, in his pocket, each falling into a different Section 1 definition of drug, where there was no direct evidence, either by way of observation or admission from Mr. Sproul, that he actually ingested one of those controlled substances, whereas the Commonwealth concedes on appeal that there was a complete lack of evidence about the effects of consuming either fentanyl or amphetamine, and where the arresting officer testified himself that the observations of impairment would depend upon which drug was consumed, no rational trier of fact could find beyond a reasonable doubt that Mr. Sproul was impaired by either fentanyl or amphetamine. Where there was no evidence about the physical or the cognitive effects of consuming either of those substances, that question that should have been answered at trial remains unproven today. And simply, there was no way to convict him of being under the influence of either fentanyl or amphetamine.
Counsel.
Yes.
You don't have to put on that proof for alcohol, right?
That's true, Your Honor. And so I'll jump.
Well, no, I want to just ask make another point, because I think it's more important perhaps. As I read Gerhardt, which you did not spend a lot of time with.
I did not.
You don't have to put on that proof for marijuana either.
Well, Your Honor, I agree that, well, I would argue that OUI drugs and OUI liquor cases are substantially different. And there seems to be, Gerhardt, which was a 2017 case, preceded this, and I didn't really get to it until my reply brief. That, I think there are two takeaways from that, is that with respect to marijuana, the effects of marijuana consumption are not so sort of widely known or accepted to a scientific level as the effects of alcohol. And so the court said that an officer could not offer an opinion unless he were qualified as an expert as to whether performance, his observations of somebody's sort of physical manifestations on agility and coordination tests, he could not testify as to whether those were the result of marijuana consumption. And I would say that the same should be true here. Counsel moved prior to trial.
You're not, and I apologize. This was my fault and I wasn't clear. I think your argument is, well, let me see if I can get it. Your argument, as I understand it, even if you could infer that fentanyl was ingested, and even if you could infer that the driver was impaired, there is no evidence to link any impairment to the ingesting of fentanyl or an amphetamine. In other words, there's no linking testimony that tells a jury how someone, if they ingested this narcotic, would have a problem driving.
Yes, that is
but
definitely part of my
says,
argument.
Moreover, I'm reading from top of page 784. Moreover, that marijuana can cause impairment of skills necessary to driving, such as coordination, concentration, and the ability to divide one's attention among multiple tasks, is within the common experience and knowledge of jurors. So here we have the SJC has already said, with respect to alcohol, this link is within the common knowledge of jurors. With respect to marijuana, this link is within the common knowledge of jurors. Isn't the link for fentanyl within the common knowledge of jurors?
Your Honor, I don't believe so. I think that I would acknowledge that there's at least one case that says that the sort of intoxicating effect of heroin, that heroin is an intoxicant, is generally understood. But it also says that sort of the amount that is necessary to consume is not within sort of general knowledge, that you need specific testimony about that. And so when you look at—
question of amount, this man hit a car, was driving in the breakdown lane so fast that apparently he scared the heck out of the cop.
Agreed.
Then he hit a car. Then he drove away. Then he gave all kinds of affect to the police officer that indicated that he was not behaving normally. He was not responding normally. Okay, so it's not a question of how much did he take. This is evidence of someone who is impaired. And my understanding of the thrust of your argument is, even if there's evidence that he's impaired, you haven't linked it to him ingesting a narcotic.
I think that I have to concede that a reasonable fact finder could make the inference that the observations that the officer made were indicia of impairment. So I'm kind of left with that position that I have to accept those as signs of impairment. But there's no evidence, and when you look at any of the other cases about narcotics or stimulants or sort of anything other than alcohol or marijuana. There is some testimony about what the effect of those substances are on a person's either physical or cognitive abilities. It's just, and I think that that's the reason when there are a couple, for example, even Schellenberger and Johnson. And Johnson's a tricky case, I think, for me, but those cases both deal with the admission, sort of the erroneous admission of a medical record, and the court there comment on the fact finder being sort of pushed to speculate about what the effect would be of sort of just the presence of that detected substance on the person, and like what left to wonder or speculate about the concentration of the substance in the person and how it would affect them. And so here where you have, we don't have that sort of affirmative confirmation of consumption. You're left with you're left drawing conclusions or speculating from the absence of information entirely. And you have two different substances.
That's a different argument. That argument sounds like that there's no evidence that there was, or there's insufficient evidence of ingestion of a narcotic or an amphetamine, which what I would put in a different category from there's no evidence linking his behavior to having ingested a narcotic.
Well, if I understand your question, Judge Englander, there was no direct testimony that ingestion of the fentanyl or the amphetamine would have X effect. There was just no testimony to that effect. We have testimony of the presence of those drugs and maybe a reasonable inference that they had been ingested, and then behavior that was not normal. Is that a sufficient link? And is there a need for more? Is it your position that there is a need for more to make that link? In other words, could have been a head injury. It could have been some other cause that caused him to act irrational, where we do not know the effect that fentanyl would have on an operator. There's just no direct testimony that fentanyl would cause him to be distant, non-communicative, monotone, whatever the other testimony was that the officer observed.
Yes, I agree that there needs to be more. And when you look at the other cases that, I mean, Booley is a fentanyl case, and there was very direct expert testimony from the treating EMT who had observed many overdoses and described what the observations would be sort of generally of a person who had ingested fentanyl, described what the observations were of that person specifically.
In Booley, my reading of the case indicated that the testimony went to the classic, that the overdose. I tried looking at Booley for the explicit testimony as to how a person who ingested fentanyl how it would impact them. If you could point me to the place in the case where it indicated that, I didn't see it.
Well,
but I
would
saw
say
only that
perhaps Booley is not the best case for the. I think Cram is I'll address what Booley. I think Booley says helpfully. I mean, Booley points out that what it does is it narrows. The defendant in Booley admits to ingesting fentanyl. We do not have an admission in this case. The testimony in Booley from the EMT confirms that the individual responded to Narcan, which binds only to opiates. So it corroborates the defendant's admission. So there's no expert testimony to corroborate a non-existent admission. I think there's some observations that he was, nearly lifeless and barely breathing. And so what the court opined was that from that testimony, a reasonable fact finder could conclude that whatever quantity was consumed was enough to render him incapable of operating a vehicle unsafely. So they weren't perhaps there wasn't perhaps direct testimony about the effects of the fentanyl, because in that case, the observations were that he was so overcome by the ingestion. But in Cram, which is a heroin case,
isn't that an effect of the ingestion? It was his being so overcome that he was practically lifeless. So there was testimony that that was one of the effects.
Yes.
And that the Narcan reversed it, which is consistent with the use of the opioid. So there was direct testimony of an effect of an opioid,
yes,
to the extent that it was the extreme effect, and
yes,
and consistent with his admission and the expert EMT's observations in other cases, and how Narcan would have affected an opioid, which was
yes.
consistent here. So there was some evidence of its effect.
There was, and in Cram, there was, something sort of a step back from complete lifelessness. But again, that individual needed to be roused by the police officer. And there was the arresting officer testified to his observations. The defendant admitted, again, there's no admission here. And in that case, Trooper Scherber testified as a DRE in Cram about the observable effects that opiate ingestion has on individuals, including signs of impairment, drowsiness, lethargy, flaccid muscle tone, constricted pupil size. Those are things that only a narcotic analgesic would cause. Now here, the arresting officer mentioned, I think very sort of obliquely, constricted pupils. Somebody might have that from an opioid ingestion. There's no evidence that Mr. Sproul's pupils were constricted. So I think the one fact that the arresting officer attributed to opioid ingestion wasn't even matched with his observations of Mr. Sproul. So I think this falls well short of what any of the cases where—
Again, I'm sorry to interrupt, but are you arguing that there's insufficient evidence that he ingested a narcotic? Because it seems to me that you have evidence that he had the narcotic in his pocket, and he had a straw that had some residue on it. And then you had an expert testify that the way that they ingest that particular narcotic is that they crush it and ingest it through a straw. Can't a jury infer from that that that's what he had done here?
I think viewing the evidence in the light most favorable to the Commonwealth, there's probably enough, if barely enough, that he used a straw to snort something. I guess the problem, and I don't want to sort of be cute.
Why wouldn't it be enough to infer that the something that he snorted is what the expert testified you snort with a straw?
Well, he's also got amphetamine in his pocket, and I'm not trying to be cute.
There was
about
no
the
testimony
facts.
that you snort an amphetamine through a straw, was there?
There was not, but he's carrying those two substances, and nothing was alleged with any specificity in the complaint, right? It left broadly the four categories of sort of prescribed substances under Section 1 of 94C. And to sort of muddy the waters, what he was charged with for distribution was oxycodone. So originally it appeared like the Commonwealth thought, oh, he's got a pill bottle that says oxycodone, we're going to charge him with oxycodone, and then it turns out that these substances come back as something else. Even if he were to have ingested something, you have to have evidence of what effect that something has on a person. And
unless it's alcohol or marijuana, where the SJC has said you don't.
I don't know that I think what the SJC
said, it's within the common knowledge of a layperson what the impacts of both alcohol and marijuana are on your ability to drive.
Is that a question, Judge England?
I see that my time has expired.
It's a question, Judge Lemire, but if we want to move on, we can.
Well, no, I want to give her the opportunity to answer the question. I didn't know if you were making a statement or asking the question.
I mean, if I'm wrong, if I'm misreading the cases, I'd like to understand that.
Well, I mean, Your Honor, what I take from Gerhardt is that, it's possible that the sort of the use of marijuana has become more prevalent and recreationally. And so perhaps that the effect of it is more commonly known throughout the general public, but still the SJC specifically said that neither a police officer nor a lay witness who has not been qualified as an expert may offer an opinion as to whether a driver was under the influence of marijuana. And I would suggest that the substances in this case are qualitatively different from marijuana and require that expert testimony to connect sort of the known effects of a drug with the observations of Mr. Sproul and to make the correlation in order for that conviction to stand. I would otherwise rest on my brief. Thank you.
Thank you, counsel. Ms. Yasulis, you'll have to unmute. Yeah.
Good morning. Good morning, Laurie Yasulis for the Commonwealth.
Let's just start with where we were finishing here. Is the effects of fentanyl or I'm having trouble saying amphetamines so common that we would be able to not need an expert or some testimony about their effects before the fact finder could make that decision?
I think in this case, what we did have was a trooper who testified, who was a 7-year veteran. He testified that he had investigated over 50 cases of OUIs and drugs, and 10 to 12 of those was for drugs. He also testified that he had received specialized training to detect signs of impairment attributable to drugs as opposed to alcohol. So I think when you have the testimony of that, plus his observations of this particular defendant, not only of him riding in the breakdown lane and side swiping another vehicle, and then instead of stopping, he just keeps going. Obvious signs that something's amiss, and he follows him off the exit ramp, and then the defendant shows no signs of excitement.
Are you saying that he was an expert?
I'm sorry, the trooper.
Are you saying that he was an expert so that he
was not recognized as an expert
about how drugs, quote unquote, drugs affect somebody is sufficient?
Well, he was trained in the effects of drugs as opposed to alcohol and how that would affect someone.
No case, not the statute, not a case, talks about the effect of drugs. They at least divide it up by marijuana, narcotic, amphetamine, alcohol. Just saying, I know what the effect of drugs is, actually sounds to me to be a little bit ignorant, and I'm no expert, but they affect you differently.
Correct.
Amphetamines affect you differently than alcohol.
In here, arguably, the defendant had the item 2 of the pills that were tested contained both amphetamine and fentanyl. So you had actually both drugs in one pill. And we did not have, as the Commonwealth concedes, any expert testimony on how those drugs would affect a person's ability to operate. But we did have a 7-year veteran who had investigated cases drugs testified about generally the signs of someone who's
Hold on a minute, Counsel. There's a lot of background. Hold on a minute. I'm not sure where that noise is coming from, but okay. Why don't you try? Go ahead.
Can you hear?
Yes. Yes.
Okay. So we did have testimony from the trooper as to his experience and his training. When coupled with what he testified regarding what the defendant displayed as far as demeanor and his actions, that was sufficient for the reasonable inference in the light most favorable to the Commonwealth that he had ingested drugs that were found in his pocket with the cut straw and that he was impaired. And we know what those drugs were. So,
well,
right,
but we don't know what effect, what physical signs would be exhibited by using those drugs. So in other words, if let's say we can infer that the presence of those drugs and the way they appeared and the fact that there was straw there, we can infer that he may have ingested them. But we don't know if they make him sleepy, hyperactive, monotone, we don't know if those are the symptoms that he was exhibiting to the officer. The officer, I think, could infer that he was under the influence of something. He eliminated alcohol because he said he didn't make any smell or odor of alcohol. You know, those things were like by elimination, defaulting back to, well, it had to be what was in his pocket. I mean, we don't know if he had taken some other over-the-counter medication that had that effect on him, which wouldn't necessarily be in violation of the law under 94C Section 1 as one of the listed narcotic or amphetamine. So can we make the leap that the presence of those drugs and the behavior alone, with the limited information the trooper had about drugs, the effect of drugs, is that enough to say he was under the influence of amphetamine or an opioid here?
I think the evidence was sufficient to make that determination in this case. There was no indication of anything else present, like you say, no alcohol. There were no other drugs found either on his person or in his vehicle. We know that he was in an accident, and we know about his demeanor right afterwards, and we know that he has these drugs in his pocket with this.
So are you asking the finder of fact to infer that what was witnessed was an effect of taking either fentanyl or amphetamine, or are you arguing that it's within the finder of fact's common knowledge that those are the impacts? Which one is it, or is it both?
I think based on the facts of this case, I think it was a reasonable inference that the fact finder could make here, that if we agree that he is reasonable inference, he ingested the drugs in his pocket, then we could make the reasonable inference.
Take that as a baseline assumption. You can that the jury could reasonably infer that he ingested the drugs in his pocket, and that they could reasonably conclude that he was impaired.
Correct. And I think it's sufficient in this case with the trooper's testimony about his generalized knowledge about the effects of drugs as opposed to alcohol. I think it's sufficient here to say that the effects of these drugs had on him. Now, you know, it's a bit hard here because we didn't have that testimony from an expert regarding what the effects of fentanyl or amphetamines is. I'm sorry? I said
I'd have to agree with that. I mean, one of the things that the Commonwealth ought to do is prove its case.
And I think we did here. I think it was sufficient here. So, you know, what we did have a trooper who could testify. He's trained on what to look for. He's received specialized training on what to look for and the effects of drugs on a person, as opposed to alcohol. And he also testified about, you know, there's certain things attributed to certain drugs, like marijuana would be a smell. And so when you have that coupled with what this defendant displayed, and if we can infer the ingestion, I think that's enough proof.
You're saying we can infer presence of drug and behavior, that drug is the behavior is the effect of that drug.
Presence, ingestion, yes. If we can infer ingestion, and based on the trooper's testimony about the effects of drugs generally, and we do have some expert testimony here on, you know,
methamphetamine. Would you be here making the same argument if what had been in his pocket was methamphetamine?
Your Honor, I don't know. I didn't really consider that. I could look into that, but maybe so, because if he has drugs in his pocket that he's ingested, and we're making inference that he ingested the drugs in his pocket, and we know his behavior. And
I mean, if you look can I just pursue
I don't know what
because I think that this is the difficulty with the Commonwealth's position. If you read 94C section 31, there's maybe 100 different drugs listed there. Now, some of them all fall under certain categories that maybe we've heard about before, but the notion that it's within common knowledge that someone's behavior is attributable to those 100 or so drugs is a tough place for me to be. I mean, we've got an answer from the SJC on alcohol, and that's understandable, I think. And we've got that statement in Gerhardt about marijuana, although it's kind of hard to unpack Gerhardt because they spend a whole lot of time telling you that you don't know what the effects of marijuana are sufficiently to know what they would do to someone on a field test, right? And now here's the Commonwealth saying to us, well, you can infer from the fact that it's in his pocket and the fact that he's behaving in a particularly odd way that's arguably impaired, that was caused by a narcotic. Well, what about methamphetamine? What about the other 100 drugs that are in 94C and that might fall into a category in Chapter 90, Section 24? This sounds to me like it's a very slippery slope.
Well, I would argue that, I mean, opiates, and I think you had asked me the question earlier about the general effects of fentanyl, and I think there was no testimony on this, but I think it's fairly common about the effects of opiates. And I don't want to make a stretch there, but there.
Are you saying that there is the common knowledge of the effects of opiates that the fact finder could have used?
I'm not sure of common knowledge, but we could look at, you know, some. I'm struggling with that. I think here what we do have is the general knowledge. We do have.
I'm sorry, you broke off again. General knowledge. In other words, we're drawing an inference clearly that the drugs that were on his person cause the effect of what the officer observed.
Correct. Yes.
Is it just the presence of one and the behavior is sufficient to cause that link, or is it there some common knowledge that the fact finder has to have to say, oh, an opioid would make you appear like distant and monotone because I've seen people use opioids, or does that not have to be present?
I think
because I think amphetamine to me means somebody who might be racy and anxious and jumpy. And so do I say, well, he mustn't have taken the one pill that had the amphetamine in it because, but I don't know what the combination of the amphetamine and the opioid would have, how they offset each other. I just don't know that. So I don't know how common knowledge or general knowledge plays here. And if it's just presence of one effect, you can draw that link. If that's your argument, or if you can state whether that's your argument, I'd appreciate it.
You know, I'm struggling also. I think it would be enough here. Based on what we know about this case, I think it would be enough. Would it have been nice to have expert testimony on this? Absolutely. We didn't have it, but we did have sufficient evidence of ingestion and impairment and generalized knowledge and an officer's experience and training. And so in this case, I feel that it is enough for the fact finder to make that reasonable inference. Could we have had more? Could we have presented more? Sure. But I guess the question is, in this case, was it sufficient? And the answer in my position would be, in the Commonwealth's position would be, it was enough here because of all the indicia of impairment, including the sideswiping of the car, and then the indicia of ingestion with generalized knowledge of the trooper who observed him and his training experience. I think that is enough. That is enough for the fact finder to conclude that the ingestion of these drugs, whether it be the amphetamine, the fentanyl, or a combination of both, was sufficient to support the conviction.
All right. Anything further?
I would just rest on my brief regarding judicial notice. We didn't talk about that. I think that the Commonwealth's position was here. It was an appropriate use of judicial notice in this case. I'm able to talk about that. Otherwise, I'd like to rest on my brief.
All right. No other questions from the judges. We'll terminate this hearing. Thank you, counsel. It's under advisement.
Thank you.
We are live.
All right. Good morning again. This is the case of Commonwealth versus McNair. 2019 P470. And Mr. Bauer, go right ahead.
Good morning. May it please the court, Max Bauer on behalf of Dwayne McNair. At the outset, there is an appellate procedural issue regarding acceptance of the Commonwealth's brief, but I'll rest on my filings, particularly 15 and 17 in this docket, unless this court has any questions. Regarding the merits of the appeal, the speedy trial right of Mr. McNair, depending on any standard of review, either procedural or constitutional, Mr. McNair is entitled to dismissal because the Commonwealth simply did not justify the lengthy delay that ensued when they went on a quixotic mission to introduce a DNA test that had only been done on a single set of twins in Germany, therefore stood no chance of admission under the Daubert factors. And the Commonwealth knew this, and as did Judge McAvoy and the defendant back in April 2014 when the case was originally scheduled for trial. The defendant invoked his right to a speedy trial. The Commonwealth said it was not ready, and they admit on pages 9, 30, and 42 that the reason they null-prossed this case was so that they could pursue this DNA test.
So,
What was
Mr.
wrong about
Bauer,
that?
I want you to assume for a moment, and I know you don't agree with this, that there was a 60-40 chance that they could get that evidence in. Would you still be here making the same argument?
I think it would be a very different case. I couldn't make the argument, and I think in that case it looks more like Lanigan, where there was a test that had met the FBI's standards, that had been accepted in the scientific community, that had been done already.
So I understand that answer. So then I guess where I'm left is, your argument then does depend on what you said at the top, that they had no reasonable chance of getting in this scientific evidence.
I think that is just
How are
positive.
we to make that conclusion? How are we to address that? What's the standard of review? What are we looking at to reach the conclusion that you need us to reach for your argument?
Well, the standard of review, much like most appellate review, is in this case, where there's documentary evidence, this court does not need to defer, and this is actually set forth at the beginning of my legal standards section of my principal brief. This court takes an independent review of the application of the law. And it's worth noting, these are not my words, but rather Judge McAvoy's. And I would certainly direct the court to page 60 of the record appendix. There is no reasonable likelihood that the Commonwealth would prevail at a Daubert Lanigan.
Or any evidence was heard at all with respect to this particular DNA, right?
Right, but that's a contrast.
So then someone else, and I think it was Judge Giles, spent 4 days with 8 experts, including some of the leading experts in the world on this, wrote a lengthy opinion in which she talks about how long it took her to, quote, untie this Gordian knot, because it was really hard. And among other things, she says, boy, scientifically, this looks like it may make sense. It just hasn't been shown yet.
Right, and the defendant is not making an argument that this is some type of scientifically invalid test in the most general sense.
Scientifically valid test should have been admitted.
Right.
Right.
So yes, and it wasn't, and this was foreseeable in 2014. So Judge Giles correctly applies Daubert and finds that it, quote, this is on page 141, arguably only satisfies one factor. But I think what's most important is that Judge McAvoy recognizes in 2014, this is, and she says it like this, what's been presented to me is a single study of twins. So that, a single set of twins. So that fails the acceptance in the scientific community. And she notes it had never been admitted in a United States court. And there was no peer review. And so you don't defer to Judge Giles in terms of the analysis that you just repeated. But her conclusions basically just confirm what was foreseeable 3 years later, that this wasn't going to satisfy Daubert because of how limited it was, and that there was no acceptance in the scientific
Does the
community.
Commonwealth know when they're in front of Judge McAvoy what additional information might be presentable to the court some period later?
I don't think they had anything
Right.
more to
What they
say
know
on it.
is that it's brand new at the time, that it purports to be a scientific basis to distinguish between identical twins. They null pros the case. They go to these folks, they get an opinion. It costs them $130,000. Doesn't sound like bad faith to me. They're not throwing that money around.
No, and it doesn't matter, and this is in Davis, it doesn't matter whether the Commonwealth had noble intentions. It's the defendant's right to a speedy trial. Courts don't second guess defendants invoking their right to a speedy trial. And that's what Mr. McNair did. And while the Commonwealth may have had every intention of trying to get this information to bolster their chances of identifying the culprit, it's not for the Commonwealth to delay trials for lengthy periods of time for some long shot attempt at more evidence. And here it was beyond that.
Well, if the test was not admissible, but it had excluded your client and in the place of his brother, would you still say the test was not admissible? And
yes, I think
there was some benefit to the defendant by taking that shot at eliminating him as the perpetrator.
Well, there would be theoretically, but it still comes down to how we analyze admissibility. The judge has to be a gatekeeper for evidence on both sides of the V. And if this did exonerate Mr. McNair, it still wouldn't have necessarily been admissible. In fact, I think under Daubert would have the exact same problems no matter what the result was. And here, unlike Lanigan, the test wasn't even done. We knew it was going to take a very long time. Judge McAvoy says 9 months to a year even to get a jury seated, and the experts of the defense say this is going to be 6 months to a year for the Daubert hearing itself. And again, the test itself that was known at the time was so limited that it had no reasonable chance, again, using Judge McAvoy's words, no reasonable likelihood of admission. So the test at some point could make it through all the Daubert factors and be a useful tool for prosecutions, but it can't happen in the context of a speedy trial, right, where the defendant has been detained for years awaiting trial, and he has said in his affidavit all the ways that he was prejudiced, and the Commonwealth doesn't contest those assertions, and that's
Counsel,
on page 114.
can I ask you, when the case was, when the defendant was arraigned after the new indictment, there was no immediate motion to dismiss for lack of speedy trial at that point, correct?
No, but he'd already invoked it repeatedly, going back to the prior indictment. Under Butler, we use resumption as opposed to reset. So those invocations constitute the invocation prong of the test. And by the time that he did move to dismiss in August,
I understand how it
Could you
I
repeat
understand
that?
how it the timing and the analysis of that, but just to your point about how obvious it was that this was never going to pass muster, that this was never going to be admitted. If it was so obvious from the outset that all of this was going to be a waste of time, I mean, the defendant didn't object immediately. I mean, again, but proceeded to engage in the discovery pursuit and in the hearings and all of this.
well, he had to make sure that whatever happened, he was covered, and he was contesting this, but he'd already invoked it repeatedly. And I believe around 46, 47 on the brief, all the times he had invoked it. And it was August 16th, 2017, he moves to dismiss. We obviously don't limit it to the invocation at that moment in time when he had already preserved it. And the defendant's experts did have to ensure, just like any good defense and any zealous advocate will do, that this was going to be, as Judge Giles found, Sorry?
Bauer, are you also pressing your Rule 36 argument?
Yes, and this is in Graham and DeRico, that they're both preserved. They were, every time there was a Rule 36 invocation, it was also speedy trials.
I understand that. I want to have a question about it, though.
Sure.
A very significant portion of the time after the second indictment was taken by your client wanting the time to respond to the prosecution's evidence. Do you have, and I take it your argument is, even though that was at our request, we needed that time, that for some reason that time is not excludable because it was in response to an argument that the Commonwealth never should have made, is the way that
That's correct. And the case law says that we don't this is in Rogers, we don't second guess those rights. We don't say the defendant benefited simply because in the end he got.
Do you have any case that suggests, any case that says, even though the defendant asked for the time, it's still not excludable under Rule 36 because the defendant was responding to a Commonwealth argument it never should have had to respond to? Do you have anything that suggests that?
Well, I think Rogers comes close. When Rule 36 rights are being expressly asserted, we will not second guess the defendant's strategic choice and conclude he's really better off for having endured the objected to delay. And as you say, everything that the defendant did in response came out of acts by the Commonwealth. And under Thomas, the case is so similar that the denial of the continuance that the Commonwealth circumvents to lead to all of this renders everything that happens to that the Commonwealth responsibility.
A continuance, a denial of a continuance. The Commonwealth looked at the denial of the continuance and said, we got a Rule 36 problem. So we have a Rule 36 problem with an incredibly problematic set of facts in terms of the crime. And so we need to make sure we don't have a Rule 36 problem. So we need to null pros. That was not in bad faith. That's what they had to do, wasn't it? Or am I missing something?
No, well, the null pros itself isn't the issue. It's what resulted from the null pros. And as in Thomas,
the null pros, I thought that I read your briefs to argue that that was bad faith. And that
no, I never used the term bad faith. And as Davis recognizes it, we don't need bad faith. It just has to be who is responsible. And as in Thomas, the Commonwealth can't say, we don't like the fact that we were denied a continuance, so we're going to null pros the case to do exactly what the trial judge told us we couldn't do. That's what the problem is.
The judge can't tell the Commonwealth not to investigate its case.
They can investigate it. Again, there's nothing wrong with anything that the Commonwealth does in its interest, as long as it doesn't violate a defendant's right to a speedy trial. And of course, that's why we have judges acting as gatekeepers, acting as agents to prevent cases from going on for lengthy appearances, using their discretion to determine if a continuance is warranted. Here, one wasn't warranted. The Commonwealth went to Judge Botsford. She says very quickly, there is no reason for me to revisit this. The Commonwealth goes back to Judge McAvoy. This is all within April 29, 2014, the date, the month of trial being scheduled. Judge McAvoy again denies the continuance, saying there's so much limited here that this simply isn't a justification for any further delay. And it's at that point the Commonwealth null processes the case in order to pursue something that they've been denied.
And that's stated specifically as the reason for null pros, correct?
Correct.
Judge Englander, I didn't hear your question.
I think I was just saying that what happened is the Commonwealth null pros in order to continue its investigation. They reached a conclusion apparently at that time that they didn't like their case without trying to be able to rule out one of the identical twins. Aren't they, I mean, isn't that well within their discretion to do that? Are they to be penalized for that?
When it comes to a defendant's speedy trial right, yes, that's the defendant's right. So the Commonwealth's interest in getting any evidence, whether it's a witness or a scientific test, does not prevail over the defendant's right to a speedy trial.
Well, but I thought at the top we established that if he had a 60-40 chance of getting that evidence in, we would not have a speedy trial violation.
I don't think it's quite that simple, but I think that these are both factors. These are all factors in favor of the defendant.
All right. Thank you, counsel.
Thank you.
Ms. Campbell?
Thank you. Good morning. May it please the court. Julianne Campbell on behalf of the Commonwealth. I'm here today asking that this court affirm the convictions for armed robbery and the 8 counts of aggravated rape for which this defendant was convicted for the 2 separate gunpoint abduction, kidnapping, and rapes of 2 separate women on 2 different dates. And the reason I'm asking for those convictions to be affirmed is because the defendant's right to a speedy trial, either under the federal constitution, the state constitution, or under Rule 36, was simply not violated in this case. With respect to the constitutional claims, obviously there's 4 factors that this court needs to consider: the length of the delay, the reason.
Let me interrupt for a moment, counsel. Sure. I'm going to ask you the opposite of the question I asked Mr. Bauer. If in fact the chances of you getting in this DNA evidence that you sought for the first time shortly before the 2014 trial were exceptionally slim, wouldn't we have a speedy trial problem?
I would suggest no, because there is no
3 years pursuing evidence. 3 years pursuing evidence that you knew you couldn't get in does not cause a speedy trial problem.
I apologize, Your Honor. I misunderstood your question. The Commonwealth was not, yes, if the Commonwealth were continuously building an investigation that frankly, with the intent that it wasn't prepared to go to trial, it wasn't acting diligently under the constitutional analysis, the state constitutional analysis at least, and Rule 36C, that would be a problem because the Commonwealth was not acting diligently. That's not what happened in this case. And there's nothing in the record to say that.
Ms. Campbell, the question was, if the Commonwealth knew their chances were slim, wouldn't the defendant have a speedy trial argument?
I would suggest he would not. And the reason is because there's no case law that suggests there's a precursor for someone seeking to admit evidence. And I think this speaks to is Judge McAvoy's sort of off the cuff opinion, which I would suggest is not a finding of fact, was not the product of an evidentiary hearing, and really should be given little weight. But it speaks to that point that there is no precursor for a percentage of how likely is something to be admissible at a Daubert-Lanigan hearing. That's why we have the Daubert-Lanigan hearing. And certainly the evidence here suggests that the Commonwealth felt this could be admissible evidence because, as this court knows, with respect to Daubert-Lanigan hearings, it's not that any one factor controls, it's all of the factors. And how a judge may weigh those factors can't be known beforehand.
But with the fact that it had only been tested with 1 set of twins, I mean, how does that impact on the chances of showing that it's generally accepted in the scientific community? I mean, that is lacking by only 1 test from what I could, and it seems to me that's what Judge McAvoy was responding to, and the defendant was pressing that this isn't going to be admissible. It's never been used other than 1 test outside of the United States. So how can you get by the Daubert-Lanigan test?
Sure.
Go ahead.
If I could answer that question in 2 parts. I think the first most direct answer to your question, Your Honor, is again, like I was just saying, the Commonwealth can't anticipate how a judge is going to weigh the various factors. I certainly acknowledge the Commonwealth knew this wasn't generally accepted in the scientific community.
I don't know if you can say the Commonwealth can't anticipate what the outcome's going to be. That is the job of a lawyer, is to evaluate the likelihood of success on whatever they choose to pursue in court. I think your argument has to be different than that.
And it is, which is the second part of my argument, that regardless of admissibility, the Commonwealth has an obligation to seek justice. And this evidence, I think it was Justice Englander who pointed this out with my brother, but this evidence had the potential to either inculpate or exculpate the defendant. The bottom line is, if the testing came back, which the Commonwealth felt obligated to pursue, if the testing came back that it was his brother, this defendant likely would not have been reindicted. So setting aside the admissibility of the test, the role of the prosecutor is to seek the truth. And this was a test that the Commonwealth went through great pains and expenses and time to research, to evaluate, to go forward with in an effort to either inculpate or exculpate the defendant. And the reality is that was a risk that the Commonwealth took when it null pros the case, releasing this defendant in order to pursue that genetic testing that could distinguish him from his identical twin brother. So in that regard, I also think that's a compelling reason for the delay here.
Well, one of their roles is to seek the truth, and another role is to efficiently bring criminal cases to trial so that people don't sit incarcerated, as this person did, unjustly. You know, I think it comes back, for me, it comes back to this question of that I asked Mr. Bauer, and I'm still stuck on, which is how do we, he says, you should have known you didn't have any likelihood of success. You say, no, we couldn't know, you said we couldn't know that, but I think more accurately, you're saying there was enough here so that there was a reasonable chance that we could win and get this evidence in. How are we to evaluate that as an appellate court? I don't know that the judge made any findings to that effect.
But respectfully, Your Honor, I don't know that the judge was really required to, because as I was trying to say, there simply isn't a barrier to someone seeking to admit evidence at a Daubert-Lanigan hearing. There's not that I'm aware of any initial showing that needs to really be made. It's a party seeks to admit evidence and an opposing party excludes.
If a reasonable attorney in the Commonwealth's position knew that the chances of success were exceptionally slim, then I think you've got a speedy trial problem. You've got someone who is incarcerated as a result of your decision and is waiting while you pursue, as Mr. Bauer has called it, something quixotic. That seems to me to be a problem. And so I'm stuck with the notion of how do we decide whether it was quixotic or not? Or am I missing something?
No, I don't think that you're missing something. I think that the Commonwealth has made it quite clear that the Commonwealth felt it would be admissible. I understand Your Honor's question that, well, if this was a half percentage that may, could have been admissible, isn't this a waste of time? I can't answer that, but I can tell the court that the Commonwealth felt it would be admissible. That's why
But suppose the Commonwealth has really bad judgment. I mean, you got, this goes back to Judge Lemire's question. How did you think you were going to get this in when there was one pair of twins that had ever been tested?
Because as the motion judge found after hearing 8 different experts, the methodology was sound. The science behind it was sound. That frankly is, in the Commonwealth's perspective, the most compelling Daubert-Lanigan factor. And again, I'd ask this court to not, the reason for the delay is one part of this analysis. And yes, whether this evidence would be admissible as part of that, but the Commonwealth had an obligation to figure out whether it was the defendant or his twin brother. And had we not done that, there certainly would have been post-conviction attacks on this as well, and motions for post-conviction testing. The reality is the Commonwealth has an obligation and takes an oath to seek the truth. And this was scientifically sound evidence that the Commonwealth could rely on to make that determination. And I think the Commonwealth was compelled to explore it. And beyond that, one of the other factors, and the reason this still, even if the Commonwealth accepted the position of my brother, that if there's no chance of this being admitted, it was a waste of time, there's other factors to consider, one of which is the prejudice to the defendant. And I certainly acknowledge that the defendant was incarcerated for a period of time during while these charges were pending, but his defense itself was not prejudiced in any way, shape, or form. And the cases do discuss that that's the most compelling prejudice.
That be the most significant thing I can think of is an imposition on someone's liberty.
And Your Honor,
putting them in jail has to be prejudice, has to be, if you're going to have a scale of prejudice, being in jail has to be kind of at the top. So I don't understand why that alone isn't sufficient prejudice. Am I missing something?
Your Honor, it is not that it's not prejudicial. I recognize that it is, and I am always sensitive to the liberty of someone who is in custody. But the cases talk about that is the case law, Your Honor, respectfully disagrees and finds that prejudice to the defense is the most compelling prejudice.
Is it?
If I could have a moment, I'm happy to cite the language.
Let me finish, because I'm really trying to understand this. Is it the notion that when you have a speedy trial argument, it comes after your client has already been convicted, and therefore, if your client's time in jail was less than what he was ultimately sentenced to, he hasn't actually been harmed? Is that the argument for why we're not concerned about incarceration as a prejudice?
Your Honor, it is not that it is not a concern, and I've tried to make that quite clear. I acknowledge, and I believe I even concede in my brief, that is a prejudice that the defendant suffered. My point, Your Honor, is citing the car and considering whether a defendant has suffered prejudice by virtue of the delay in bringing him to trial. This court looked to the interest that the speedy trial right was designated to protect, namely to prevent oppressive pretrial incarceration, to your point, Your Honor, to minimize anxiety and concern of the accused, which I understand, and to limit the possibility that the defense will be impaired. And then in Dorico, the court goes on to say, the potential impairment of a defense from delay is the most serious concern when evaluating whether the defendant was prejudiced. And I understand that Your Honor may disagree with that, but I only bring it to this court's attention to highlight in terms of weighing the factors as to whether there was a speedy trial violation here. He did not suffer the most serious prejudice that the case law has discussed.
Well, as I understand it, your position is that anything prior to the null pros wouldn't count, just because there was no, up until the time of the request for the continuance, there had been no assertion of any speedy right rights. That the null pros was a result of learning in April, according to the Commonwealth, that of a test that was published in December, the prior December. So you're talking about a 5-month period for the 5-month period, that between the test being published and the Commonwealth becoming aware of it.
My position is that the speedy trial right was not asserted by the defendant until April 16th of 2014, when the Commonwealth sought the continuance. That was the first time it was ever lodged. And then again with the null pros, which I believe a copy is in the Commonwealth's appendix, in which it explicitly states that it was April 2nd of that year that the ADA assigned, now Judge Deakin, had actually learned of the testing himself personally, and the trial date was scheduled for April 29th. And again, in Justice Deakin's affidavit, he specifies that he had been reviewing DNA advancements throughout the course of this case, and it was unfortunately only the same month of trial that he learned of it.
Isn't the reason that the speedy trial right wasn't invoked until April of 2014 that there was no basis to invoke the speedy trial right until April of 2014? I mean,
Your Honor, I can't speak to why the defendant did or did not lodge a speedy trial objection. Certainly the case took over.
But I think what you're trying to do is you say, well, let's when we're talking about speedy trial, let's just focus on the 3 years between the re-indictment and the time that the case was actually brought to trial. And your brother says, no, it's 5 years because we go back to 2012. And you say, oh, but you didn't even raise it for the first year and a half. But there was no reason to raise it for the first year and a half. They had a trial date that was fine.
Your Honor, respectfully, defense attorneys routinely lodge objections in the trial court for Rule 36 and speedy trial purposes to preserve their appellate record. That this defendant chose not to. I can't speak to the reasons why he chose not to, but he did not. He didn't make an objection until the Commonwealth moved to continue the trial date.
I'm not sure that means that they can't go back to 2012 when it turns out that it's 5 years instead of 3.
But one of the factors to be considered is the assertion of a speedy trial right, which the defendant did not do for several years during the pendency of this case. And if I could just, unless the court has further questions, I'm happy to address them. I'd suggest that the defendant, I acknowledge that he preserved claims with respect to Rule 36C, both the motion, which is in my brother's appendix, and the memorandum of law in support of that, which is in the Commonwealth's appendix, specifically at page 39 of the Commonwealth's appendix. The defendant simply moved to dismiss under 36C, not 36B. I did include the Commonwealth's position on calculations for Rule 36B analysis, should this court reach it, but I would suggest there's no basis to do so in which the defendant below did not move under Rule 36B. Unless there are further questions, I'm happy to rest in my brief.
There appears to be no further questions. Thank you.
All right, we are live.
All right. This is the final hearing of the day, 2019 P1261 SM versus JB. Attorney Cook, go right ahead.
Good morning, Your Honors, and thank you for your time today. I'm representing JB in this matter, and the event string from the dates of February 6th, spill over the same incident on the 7th, and then include another on the 16th of February of 2013, and led to SM seeking a harassment protection order on February 19th of 2013. The order was initially granted and ex parte, and then there were hearings that extended it over consecutive months thereafter. JB was.
So you agree, Attorney Cook, that there has to be a finding of fraud on the court in order to expunge the evidence of this order?
Yes, Your Honor, and I guess.
And the judge below did not make that finding.
That's correct. And we believe that it's a JB's position that the judge below applied a higher standard in determining whether fraud existed or not than is actually required. We offer that in the Adams case, where specifically where fraud on a court is defined. Fraud on a court has been found in cases where a party has perjured him or herself on a court, and the court has relied on the fabrications when reaching a judgment. So falsehoods of the court that are in a calculated pattern of false statements is sufficient to rise the level of fraud on the court. We believe JB presents that he, in his lower court matter, he's presented sufficient a showing that such an incident existed, and if in our
identify what the fraud is. What was it that you contend is fraudulent?
There was yes, Your Honor, I understand your question. There was a calculated pattern of false statements that evolved and escalated.
Which are what? What are the false statements? What have you proved was a false statement?
That SM put forward that there were 2 to 3 no trespass orders that existed, and yet JB kept returning. That was not correct. That was false. She said that she had made warnings to her boss about his behavior repeatedly and over time, which was shown not to be correct. She said that he had been asked to leave and kept returning, which was shown to be false statements and not correct. That she had asked her boss to walk and others to walk her to her car, which was shown not to be correct. That there was multiple police involvements, that she had been to the police station and sought their assistance on multiple occasions, and that was shown not to be correct.
Go ahead, Jim.
Oh, I was going to say the police, there was just no police reports. I mean, that doesn't mean she didn't arrive at a police station and make a complaint and they said, you know, there's nothing we can do.
If there was no record of her ever, not even a report, but not even an incident, incident report was taken. It's not only, you know, of course, you know, not even a high level report, but
did you see,
incident.
I mean, I didn't see in the record that your client sought that out. In other words, the fact that she didn't present it, is that the lack of record of it?
No, we subpoenaed, and it is in the record. I believe we subpoenaed the appropriate police department in New Bedford for any record of interactions with her and with him during this time period, and there were none.
But you acknowledge not everything would be necessarily documented. Every encounter between a citizen and a police officer is not necessarily documented in an incident report.
I understand what you're saying, and I agree, Your Honor. That is true. What we were trying to do is all that we could to show that, again, it is a threat.
Right, but the problem, counsel, is when you give us a litany of things that you have shown to be false, all right, then we need to evaluate whether that is an objectively reasonable view of the evidence presented to the court. And what I read is she said that she went to the police station and they said they couldn't do anything. The fact that there's no police report does not prove the falsity of her statement that she went to the police and they said they couldn't do anything.
I understand what you're saying, and I would concede the point that you're making. Unfortunately, for what JB has gone through, that is just one small piece on a huge pile of tinder that led to his situation. And because also that she said that, you know, he was waiting in the parking lot for her and she reported that to people and no one was reported as seeing that.
Where did she say that she had reported his waiting in the parking lot to people?
Well, that happened at 2 times. She said that she told people that she worked with that her supervisors, and each of the affidavits from her supervisors show that none of that.
I can't find, I struggle. So this is my problem perhaps, and I don't want to take too much time on it, but I see where she said he was waiting for me in the parking lot. She testified to that. What I don't recall is where she said in one of those 3 hearings, I told my supervisors about that. And that's, it seems to me, where you start to get traction because you then have the supervisor saying, she never told me that. So where in her testimony does she say, I told my supervisors?
Well, I don't think that it's there. And the reason that I believe that actually, that's concerning, because if with all the other steps that she's allegedly taking because of this concern she was presenting, to mention nothing to anyone that was there, to, you know, where she said that she had talked to her made several warnings to the boss, but whatever these warnings to her boss were, it never included, oh, and he's waiting for me in the parking lot.
But counsel, now you're getting into credibility determinations and not an establishment that what she testified to was false. In one of the hearings, didn't she have her father there who sort of corroborated that she was so concerned that he had to go pick her up?
That's correct. And he also testified that when he was there, there was nobody there. He never saw JB there. So again, I offer that this is, it's a.
You have to show fraud on the court. And Adams tells us that if you make enough false statements, that can be fraud on the court. And then the case, the 90 mass case, DED or whatever it is, says, but it really has to be systemic. It's not enough to have made one. And so, how do we do that? Because we have, okay, so the statements that that there were no trespassing orders, there's no evidence that there was such a thing. And she did say that. The statement that he'd been thrown out 2 times appears to be false. He was only thrown out once that there's any evidence of. Beyond those 2, what else?
Well, the photo that was left for her, which was simply not the
But
case.
wouldn't that just be a misunderstanding on her part? What did she say about that was evidence of a deliberately false statement?
Well, that she conveyed to the court that it was specifically, she was told that it was left for her, and there was no evidence that the person who had aware.
And Reynolds denied that. She said, I never told her that, right?
That's correct. Yes, sir. So we have these 3 to 5, significant events, which, and if you watch them over the course of the different hearings, they evolve, and I offer that they escalate such that it's always enough. Because remember, she had failed to get some prior orders, so she got better at it, and JB suffered from it. And this is what happened, and it was just enough over time.
I'm sorry, what were the prior orders that she failed to get?
There were 2 other incidences where she sought harassment protection orders against young men.
And was that established in the record, or was that just a representation?
I'm sorry, I don't understand your question, Kat.
Was that a representation of counsel that she had failed to get prior orders against other people, or was that established by some sort of, documents?
Yeah, I have seen, I'm aware of, and I've seen the documents related to it, but
Is it in our record?
I don't know here if it's here besides as representations or.
There's a reference to it in, it was the 2nd or 3rd hearing. I think it's the 2nd hearing. And the judge spent some time pressing her on it, as a matter of fact. But there's nothing specific, except that she says, oh, as to one of them, the guy went to jail, so I didn't have to pursue it. Do I have that right? Does that sound right to you?
Yes, Your Honor, it does. Yes. So, and unfortunately in the lower court decision, I understand without a finding of fraud, there's no reason to get to the, they can argue that there's no reason to get to the government interest versus harm suffered analysis, but clearly, as JB presents, there is enough here for a finding of fraud, not just in the 1 hearing, but as it moves through the hearings, and that as we look at the balance between the government interest and the harm suffered, there's no danger here that this is for future law enforcement.
Were you her counsel in the libel or slander action that he brought, his counsel, pardon me?
I was, yes, sir.
You were, okay, so you took the deposition that's in the record?
I did, yes, sir.
What was the result of the litigation? I know that I'm asking outside the record, but we are in a situation where there is no red brief, and I don't think it's an unfair question.
No, the matter was dismissed because when we looked at the totality of what we could actually bring on the question of what happens, we.
Okay, all right, thank you.
No, I believe that there was a representation in the record that it was dismissed on summary judgment.
Yes.
Okay, thank you.
Yes. So in getting to the question of the balancing of these interests, the harm suffered from JB has been significant, longstanding. His not only his identity, but his work experience and all comes from his decorated military experience and his ability to participate in law enforcement. And that has just been, it's, as I'm sure you can understand, it's not possible for him as he can't pass a background check. And this is over something that, again, we believe, satisfies the question about fraud in a court. And so when you look at the benefit, gained by the government interest and the benefit they may gain there, it not only does that not exist, but it pales in comparison to the impact that this has on him. It's keeping him from pursuing the career that truthfully, his whole professional life has prepared him for. And so he is seeking to ask this court to overturn that decision and allow him to pursue the life that is ideally suited for him. And with that, I'm happy to answer any other questions or spend any other time that is helpful.
Seeing no questions of the court, we'll accept your argument, and you can rest on your brief and the argument submitted. Thank you, counsel.
Thank you, and I hope you all have a great day.
Thank you. This ends the hearings for today. I will send an email to the two judges scheduling a hearing on our meeting after the hearings.